Matter of Parker J.
Good morning, Your Honors. May it please the Court. Excuse me. Good afternoon, Your Honors. May it please the Court. Bill Rothschild, Hiscock Legal Aid, on behalf of Appellant Beth F. Parents in family court.
Do you wish to save any time for rebuttal?
Yes, 3 minutes, please.
Yep.
In family court, the parent's right to counsel is guaranteed by case law, statute, and the constitutions of both New York and the United States. This presumes that counsel is effective as more than just the pro forma appointment of.
Now, it's been said that with respect to rights in criminal cases, there is a right to effective counsel. Has that been decided the same way for family court?
Yes, I believe it has, Your Honor, that the right is essentially equivalent for family court.
And what does that encompass to be an effective attorney?
I think it depends upon the context and the circumstances.
And here, what was not effective?
Well, the context here is that counsel did not meet with, there's strong proof counsel did not meet with the client in the 7 weeks that this case had been pending.
What about the fact that the record is silent as to whether it was because counsel couldn't contact her, or because she was in counseling? What are we to do about that?
I think that, if we can all agree that the right to counsel is paramount, this court's obligation is to basically, it's the searching inquiry that really has to be done. In Ferretta and all these other cases.
I'm sorry, are you saying that the court here failed to do some sort of inquiry that it was supposed to do?
I believe it did some sort of inquiry.
With regard to what? Not the decision to go without counsel. There was an inquiry made on that, right?
There was an inquiry, Your Honor. However, I believe that, as this court has said and other courts have said, the waiver requires a searching inquiry, and that is dependent upon the circumstances. You must show that the party understands the stakes and nature of the case. Obviously, the stakes are very high. The nature of the case involves many different factors. The procedure,
So is the ineffective and the waiver one and the same, or are they separate questions?
I think that ineffective assistance of counsel, I think that when the court is on notice of something, I think it has an obligation to inquire. Given the fundamental right to counsel, the court has to do a inquiry which is based upon what occurred below. And what occurred below here was.
But to be clear, I thought your position was that based on the record as it stands, counsel was ineffective.
I think that
Number one, you've already said in response to Judge Troutman, because I think you said approximately 7 weeks hadn't met with the client, but I thought you had other grounds.
Yes, there were other points. The fact that it's pretty clear that counsel had not reviewed the papers that had been subpoenaed. And that's our argument. Obviously, there was no inquiry by the court. There should have been inquiry by the court as to that. But most importantly, when counsel said this, counsel also said, well, because I haven't had a chance to meet with her, I would like to remain mute. Now, in the terms of the waiver of counsel, I think that's a very important, that's kind of like
But counsel, the lawyer there was told by the court in no uncertain terms that that wasn't an option.
Yes.
Remaining mute is not the right thing to do.
Absolutely.
So then what was the ineffective act once counsel was advised that they were going forward?
I think the problem was, what the court said was, basically, it doesn't matter, this case is going
But
forward.
let us focus,
Yes.
we're asking you, separate out ineffective versus the waiver. Can you be ineffective regardless of the waiver being valid?
I believe you can.
And in this particular instance, what was ineffective on the part of the attorney? Not what the court did or did not ask with respect to the waiver. Let's wait for that. What was ineffective here?
Failing to meet with the client, not reading the papers, not moving for an adjournment, not joining in the motion for adjournment by co-respondents counsel, and then saying, I'm going to remain mute.
I wanted to ask you about the adjournment. Do you think if counsel had either joined or sought an adjournment or continuance, that would have obviated any freestanding claim of ineffective assistance?
I think that would have given counsel an opportunity to talk with Beth in this case, because here there was not even that opportunity, even when they got to court. Because
And so would a claim for ineffective assistance still lie in that event?
I think it's definitely a violation, it's arguably a violation of the rules of professional conduct. That's the type of behavior that can get you sanctioned,
Right,
grieved,
but-
possibly disbarred.
Okay.
And
Suffice it to say, maybe a significantly less compelling claim of ineffective assistance if the lawyer had either joined in or sought the adjournment.
Yes, I believe so. But
And is that the judge's responsibility to sua sponte, make a determination about ineffectiveness? Because I don't believe the client here ever expressed dissatisfaction with counsel, right?
I believe the court said, what is the problem exactly? And she said, well, I'm exercising my right. But I think there's a couple factors that go into this to show the context behind it vis-a-vis the waiver. Basically, this judge made it very clear this case is going forward regardless of whether you've spoken to your
But
client
is
or
the
not.
rule that you're asking for that the judges on their own have to make a determination about ineffectiveness and then do a further inquiry?
No, I believe that inquiry has to come when when the person says, I'm going to waive counsel, because that is the
And what
searching
kind of inquiry? Must there be an inquiry that says, look, you can get another attorney?
Yes.
So you're asking for a rule that says every time,
No. No, it's not a formal catechism. It's
Then how is that workable?
I
There can be, trial courts have great discretion, and there are times when one person will ask for multiple attorneys as a delaying tactic. So we're
Which was
trying
not
to
the case
figure
here.
out how this is going to work. If I have to tell you, well, you can get a better attorney, or you're saying the court had to sua sponte say, you're entitled to a competent attorney, when we're not clear here that she was complaining as to the lawyer's competency.
Well, I think that the whole question of the waiver is you have to understand what you're giving up. And here, she was never informed of that.
So are you suggesting that because of the circumstances here, the request was infected by the fact that the attorney was ineffective in the first instance?
I think clearly so. In this case, Beth didn't know that she had the right, and when she subsequently asked for it, she said, I didn't know. I didn't know that I wouldn't be able to consult with an attorney. I didn't know. I didn't know what a dispositional hearing was. I think under the facts of this case, and I think as a matter of public...
And that would be an error by the court, according to your argument, right? Essentially, you're saying the court erred in, if I understand you correctly, the way the court addressed the ineffective assistance of counsel was to entertain the request to go without counsel, but in the process failed to advise Beth that she could have another lawyer, possibly a better lawyer.
Two questions, Your Honor. It could have solved this very easily. The court could have said, are you doing this because you want to represent yourself, or is it because you have an issue with counsel? If she says, I want to represent myself, that's it. If she says, I have an issue with counsel, then, as in the Dion M. case, as in the David V.V. case,
Yeah, but how would a court know to ask that question if a client never raises that they have an issue with counsel? So I go back to, so you're asking for a rule that says in every one of these cases, you'd say, or do you have a problem with counsel? There was no hint that there was a problem with counsel on her part.
Well, I think that any judge looking at this would say, there's an issue here. There's a real problem because this attorney...
Do you think this judge would have said that?
I think this judge would
Okay,
not have said that.
so now we're back to square one then.
But I think that the importance of the waiver is because New York is committed to preserving families whenever safely possible.
So are you suggesting on this record, this judge should have done more because the record exists that the way it does?
Yes, Your Honor.
And what is an argument for not speaking to someone until after direct examination has occurred? How do we justify that as effective?
Well, not speaking to someone until after direct examination has occurred, you mean what occurred here is
Correct.
She was not given an opportunity to even speak with counsel until...
And how does that affect counsel's ability to represent as an effective attorney if they didn't speak to the client before that, even that direct exam?
Under the rules of professional conduct, you have to diligently make efforts to meet with your client. How do you know what your client's wishes are if you've never even spoken to
So
your
was it
client?
counsel's responsibility to put on the record if in fact those diligent efforts had occurred?
I think
Or
that-
attempts?
I think given, under this court's ruling in Medina, the People versus Medina, there's an obligation of the court to be solicitous of defendants and family court litigants' constitutional rights. I
So
believe-
why is it so clear here in your view that the judge had to do more with respect to the waiver?
I think the statement that I intend to stand mute, when I
That's
saw
coming from counsel.
counsel,
But with respect to the waiver question, why is it clear that the court had to do more?
because normally when you see something like that, I don't know about you, but first thing I'm thinking is, I'm probably better off representing myself. And the question is, does she know, in fact?
But
So you
counsel,
think-
but counsel, you said, first of all, there's not a formal catechism, right?
Yes.
You can address these things in different ways. And then you said, well, he didn't ask her why, but I've got the transcript in front of me. The court says, after she says, I want to represent myself, that's my right, and he says, or the judge says, well, you don't get to ask me questions, ma'am, but what is the problem exactly? Why isn't that good enough for her to say, well, this lawyer's terrible, or this lawyer's not representing me well, or the lawyer's not working on my behalf, or I'm unhappy with my lawyer?
Because the court really has to look at all the factors here, the viability.
No, I'm just asking about this
Yeah,
question.
in this question-
What is the problem exactly? Doesn't that open or allow for the opportunity for her to say, I'm unhappy with my lawyer?
That assumes and presumes that she knows that she has the right to a different lawyer.
Why does it presume
No,
that?
it just, he's asking, why do you want to represent yourself? She could have said, because the lawyer's doing me a disservice. I'm not happy with that lawyer, I'd rather just represent myself.
I think to expect that of litigants in cases where we have a judge who's clearly moving the proceedings along at a very rapid rate.
But
where-
this client says, it's my right to represent myself. So why isn't Judge Rivera correct that that was the opening to offer as to her
I think that-
rationale?
I think that presumes knowledge on the part of Beth, which.
But she asserted her knowledge.
Yes,
She said,
she-
it's my right to
Yes,
represent
She asserted
myself.
her knowledge as to that, but the question is, did she know that she was giving up her right? You know, clearly, when the inquiry went on, as far as her later request to have other representation, she said, I didn't know. And the court, at that point, basically cut her off. Didn't
Chief,
want to
I
know.
Just want to clarify
Yeah.
one issue. You've repeatedly said during your presentation that the court didn't provide an opportunity to confer with counsel, and I thought the record was different, and please correct me. On the day of the fact-finding, when counsel disclosed that he hadn't had an opportunity to speak with his client, there was some discussion. I think there was some talk about a surrender. Maybe she was going to agree to that. And then there was a break, and I thought the court said, if you want to confer with counsel, and I think it's by Zoom, we're going to take a break and you can go do that.
I think it would have to have been by phone.
Okay.
Because there was talk about that. I don't believe that it was actually shown because my understanding is the first time she actually had a chance to speak to her attorney was during the break, and right after that, he announced that she wanted to represent herself. That's my understanding.
So you're saying there was no discussion, but the court allowed it, and I guess that's an important issue. I mean, counsel could have come back and said, thank you very much for giving us the opportunity to confer. We weren't able to do that, so I'd like an adjournment, I guess, or something like that? Is that something that could have happened here?
I think a lot of things, it could have happened, but obviously there was no request for adjournment by counsel.
Well, we don't know, because none of this is really in the record. And
Yes.
that's such a huge problem in this case. How do you judge the ineffectiveness of counsel when we're all speculating as to what that ineffectiveness even was, or what the client wanted?
But isn't it also incumbent upon the court to make the searching inquiry in order to make the record to show
Well, you
this?
just had Judge Rivera give you an example. The court asked the question, what's the problem here?
And she said, I have the right to represent myself. And I don't believe that that is sufficient under the facts of this case, given what had occurred and given what was said. And I see that my time is up.
Thank you.
Good afternoon. Attorney Lisa Sapino-Cuomo on behalf of the County Attorney, Onondaga County. I would respectfully submit that she, the appellant here, unequivocally asserted her right.
Well, before we get to that, why isn't he correct about the actions or inactions that counsel took or didn't take enough to establish that counsel was ineffective?
Well, as the court may recall, she did not appear on the first appearance. She did not appear after having been subserved on the second appearance, and the court took
She wasn't served on the
note of
first,
that.
if I'm remembering correctly.
She was not served on the first,
okay.
subserved, they requested substitute
Right.
service, she was subserved on the second. She did not appear, and then you see on the record that she then was notified, the caseworker was able to notify her somehow, they found her. And she appeared having checked herself into a drug rehabilitation.
But what does that have to do with the counsel saying, I haven't met with her?
Well, so what I guess I'm getting at is, how would he meet
And the
with
counsel
her?
not showing up himself, or?
He was
At
excused.
the hearing also.
Well, no, he was excused from the January appearance. It was specific on the record that he was excused that day for that specific appearance. And
Let's separate out effective assistance of counsel from the waiver.
I agree with that.
What did he do in this instance, and what's on the record to show what the reason or the lack of contact?
There's nothing in the record, it's pure speculation.
And
to
isn't
say-
that a problem?
And doesn't that fall on the shoulders? I mean, it's an odd argument I think you're trying to make there, that the fact that the lawyer may have been ineffective for failing to make a record to explain why they had not met with their client makes it impossible for any court to decide that the lawyer has been ineffective.
However, he did request to speak to her after the
No,
direct
we're still on
examination.
this first one,
Okay.
before you get about asking to speak to her.
By
I mean, isn't
him-
it the day of the trial?
By him not making the record, I think it was clear that she appeared.
That's a startling thing to say, that weeks have passed and I haven't met with my client.
But I think it was noted on the record that she had checked into a drug rehabilitation.
But again, that involves speculation as to it was her as opposed to him. Is that what we're supposed to be doing?
Well, it's absolutely unclear.
And most lawyers, it was my experience as a trial judge, if you impugn them with respect to not being effective, not meeting with the client, they're ready with an answer as to what, if any, obstacles prevented it. But here we have none.
But at that time, she never complained about her representation.
So let me.
In fact, when she invoked her right to counsel, her right to waive counsel, the judge specifically asked her, what is the
Well,
problem?
it is possible that someone who is not steeped in the law may not understand.
But she was
May not
savvy.
understand that their lawyer's actions or inactions rise to the level of ineffectiveness, may not understand that they can raise that complaint with a judge.
Well, she was savvy enough in a subsequent
But even if
appearance.
she didn't know, can you find your way to perhaps agree with me that even if she didn't understand that as a matter of law, that nevertheless the lawyer could have been ineffective as a matter of law?
Well, I would argue that he would be ineffective if he hadn't contacted her for 2 months and they
What
had
about
had
the
no
rest of it?
meaningful
But that
conversation.
was not the only basis that counsel has
Well,
argued.
we have to remember that he did make objections. He asked that the records be
Okay, but
redacted
let's
of
go back
hearsay.
to, you seem to not disagree with the fact that he did not have an opportunity to speak to her prior to the completion of direct examination. Is that accurate?
Yes.
How do you effectively represent your client if you don't know what the strategy is while that person's testifying, before that person testifies?
Well, I think the county bears the burden of proof indicating whether her
But
rights should
to
be
represent your
terminated.
client,
No, I understand what you're saying. The problem is the record.
how is that effective assistance of counsel to not speak to your client before a witness is called, to know what the defense strategy is?
He specifically said to the judge, I have not had an opportunity to talk to her, and that's when the court adjourned so that he
So-
could have a conversation with her.
No. He said before he hadn't. Later on, he didn't ask for an adjournment. He didn't ask for an adjournment until after there was direct testimony. You're saying that's proper representation of your client, to wait until witnesses have been called and then ask for an opportunity?
Well, I think it's noteworthy that the other counsel asked for an adjournment. and
They
the court
did,
denied.
and normally that's the cue for the other attorney to say, I join in that motion, even if they have forgotten, and that was not done here.
Well, I think he took into consideration when he used this idea of standing mute.
But
that the
again,
court
you're
had already-
assuming, you said you think, because the problem is the record,
But the
right?
court had already made a finding prior to that. And then she said, now that she's here in a virtual appearance, then I'll let her participate.
So let me try hypotheticals instead of the facts of this case for a minute. So suppose a lawyer shows up in court and says, I've never met with a client, never spoken with her, I don't know what this case is about, there's a bunch of documents that are produced that I haven't looked at all, I'm not ready to try this case, and so if you ask me to go forward, I really can't effectively represent whoever this person is who's on the TV screen, and the court says, doesn't matter, you're going forward anyway. Is that a deprivation of the right to counsel?
Yes.
Counsel, can I ask a different question? This lawyer is appointed
Correct.
off of a panel?
Yes, so Onondaga County has a panel of lawyers that they select and assign.
And-
He has been on many cases in
And
Onondaga.
hypothetically, not this lawyer, not this case, but if you had a case where there was a finding by a court that there was ineffective assistance provided by one of the panel lawyers, what would the county do?
The county or the county panel?
Would you take the lawyer off the panel?
I would imagine that there would be severe repercussions as a result of that.
Have you ever seen that?
No. I would also note that we have very few lawyers in Onondaga County who are actually taking these type of cases. But I think we're losing sight of the fact that she unequivocally invoked her constitutional right to represent herself, and she never complained about.
Are you
But how
saying that
does that-
somehow that erases or makes up the fact that the lawyer, let's just say for one moment, was ineffective?
Well, what I'm saying is.
Why does that matter?
Counsel is saying that she did that as a result of his ineffectiveness.
Well, she may have, but
But-
if he's ineffective, aren't we done?
Well,
If he's
then-
ineffective as a matter of law, aren't we done? It doesn't matter if she says, I want to represent myself.
But is he ineffective as a matter of law? The court would have to say.
Well, I'm asking you,
then a
let's
finding-
assume that the court reaches that conclusion. Do you
Okay.
agree
No.
then the
No.
issue
We
about the
wouldn't get
waiver,
to
we
that.
never get to it?
Correct. You would never get to it. However, if you're going to say that he's ineffective as a matter of law, then you would have to delineate, specifically make a finding that he never contacted her, that he knew where she was, he knew what she was doing. She moved on to.
What about the record clearly saying, never talked to her, never spoke to her, and a witness has testified? Or even considering, you did say, the chief's hypothetical, you agreed if those were the facts, that's ineffective, correct?
I
How
would-
is this case different?
Because he requested during the direct examination, the direct examination was not concluded.
So it's okay for a lawyer to never speak to a client before a hearing starts or a trial starts. That's effective assistance of counsel.
But then you have to take into consideration what,
No, it's a yes or no. Is it effective assistance of counsel to go forward with representing someone without having spoken to them or not even being clear as to what your trial strategy is, or having reviewed documents that you may or may not have subpoenaed?
I would say yes.
It's effective?
It's not effective.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. Susan Maris, attorney for the children who are 5.5-year-old twin girls who left Beth's care when they were 6 months old and have never returned. Getting to the issue of effective assistance.
Counsel, before you leave that point, one thing I struggle with in cases like this, you make a compelling case for the children and how long they've been in care, and also how long these proceedings take, and they've continued in care, and this delays things further. How are we to factor what you just said into our analysis of the ineffective assistance issue?
Because children have rights. The statute 384B and this court's interpretation of that statute say that children are entitled to a safe, permanent home. And when a biological parent can't provide that, these children need to be freed for adoption.
So let me follow up on Judge Garcia's question. Supposing what happened here instead was the court told the mother, we're not providing you counsel at all. I'm sorry. You have no right to counsel. You have to proceed on your own. And there was no lawyer there or anything like that. You would still say the same thing? That is, the children have been 5 years out of the mother's care, and therefore it doesn't matter that her right to counsel was denied?
So I think it depends on the facts of the case.
So I've given
In
you
your
a-
hypothetical, it's a harder decision to make.
But so you might still say that even in that circumstance, there's a complete denial of the right to counsel, the amount of time that passes could vitiate that.
I think it can, because this parent has never made progress. She testified that I have an addiction. I cannot provide a safe home for my children.
That's the point. All of that is potentially, arguably, done without having had the benefit of counsel to present her in the best light.
And I don't think those are the facts of this case. So getting back to
In a termination of parental rights, does a parent have the right to effective counsel?
So I don't think this court has addressed that, but all.
I'm asking you the question.
They do. I think they do, and the appellate division said they do. I think they absolutely have a right, but it's their burden to prove ineffective assistance of counsel.
But aren't you putting your finger, I think, on what's so difficult about these cases? If there is that right, and it is violated in some hypothetical case, don't we have to do something in response to that, like we would in the context where a criminal defendant's right to counsel is violated? And I'm not sure how we balance that against the very compelling concern you are advancing, which is the passage of time and the effect on the children. But can we say that the right has no traction and can be violated with no consequence simply because of the passage of time? It seems like a very tough conundrum that the courts are in that circumstance.
And I think, Your Honor, it depends on the facts of the case. I have another case.
So are you saying I'm sorry, maybe you were just going to do, they're not egregious enough in this case? Is that your argument?
It is egregious in this case because this parent.
So they're so egregious that even though the mother may have been deprived of the assistance of effective counsel, here the children's interests supersede that legal error.
Absolutely, and I think, again, the statute, 384B, provides for that. And this court's interpretation.
But it's a constitutional right that's at play, right? So how does that, how can that overcome whatever a statute would set forth?
Well, again, it is a constitutional right to the effective assistance of counsel, but in this case.
There's a constitutional right also to the care and custody of your child.
Correct, Your Honors.
Got a little double whammy here, right?
So it's a balancing, I don't know.
Those are on the same side.
Oh,
those are on
I'm sorry,
the- she lost her children.
But the statute in this court have said the child's right to permanency in a safe home take priority over the goal of returning a child to the biological parent. That's well-settled law.
But isn't that the assumption there, is there's a process, there's representation on both sides, and then there's a determination based on a record. supporting that determination. I didn't hear you say that that assumes that the right to effective assistance of counsel can be dispensed with. You did not say that.
What I'm saying, and I think it's a case-by-case factual determination, and in this case...
It's a case-by-case factual determination as to whether you're entitled to effective assistance.
No, you're entitled whether you receive effective assistance.
So then where do you stand on this question that we've been, looking at, which is in a case where assigned counsel does not speak to their client or has no communication with their client for approximately a month before an appearance in court, and then comes in and apprises the court of that fact, whether that is ineffective as a matter of law or not?
So it is the person claiming ineffective assistance of counsel to prove it. They have to, it's their burden of proof. So you have to look at the record as a whole, and maybe this attorney had a legitimate...
So was he ineffective or not? It's like kind of a yes or no. As a matter of law on this record.
On this record, no.
Why not?
Because he may have had a legitimate
Hey,
explanation.
let's say you're right about the failure to meet with her. What
Okay.
about everything else that has been described as alleged failures?
It's all speculation. There's no evidence in the record to support that
You mean the failure to ask for an adjournment is not clear from the record?
So you look at...
Proceeding
that's-
with a
that-
witness?
You know,
with-
she's entitled to effective assistance, but that's not perfect representation. Okay, that may be one error, but the judge already denied other counsel's request for an adjournment. I'm not saying he shouldn't have asked, but it's one error. When you look at the totality...
Well, we just went through two. He also mentioned the lack of familiarity with the documents.
We don't know that. He made a statement that said, do we have those records? It's 500 pages of case notes.
Well,
It does seem that there's enough of this from your side trying to kind of explain it all the way. At some point, you just can't. There are just too many things that appear to suggest that the lawyer was not prepared in this case.
I think that's speculative, Your Honor.
Why is it speculative in the other direction? Why is it speculative
It is.
on your side to say he was
It is,
effective?
but the burden of proof is on the applicant.
But again, see, you're making the same, what I said was the odd argument of counsel, that the fact that the lawyer may have been so ineffective that they failed to provide the kind of record that we could actually review to say they have or have not been effective is what renders this case troubling.
Well, what's troubling
Why should she pay the price for that? She's not a lawyer.
is that he didn't get a chance to present her defense because she got rid of him in the middle of the first witness. So that's why it's speculative. When you look at
He didn't seem to have any defense because he hadn't talked to her.
I don't know that well, he didn't talk to her, that we know, but he did. He went on the phone and they spoke. We don't know what they said, and then they come back.
I think most clients would feel uncomfortable moving forward with the trial after a few minutes on the phone with a lawyer.
But that's not the lawyer's doing. It's possible she was in rehab, and in fact, the agency couldn't serve her personally because she was in rehab.
Let's just say for the, Chief, could I have one?
Of course.
The judge said you get 5 minutes. Let's just say for the sake of argument that you're correct, that there was a self-correction after, it's like, we're not going forward, I'm going to give you the chance to speak to him. 5 minutes? That's enough time to figure out a defense and everything, too?
No. Well, he may have figured out a defense. We don't know that.
And reviewed those 500 pages of records that you just described?
Well, and again, I don't, they're case
Therein
notes.
lies the problem.
Well, I think, again, when you look at the children's rights, they take, in this case, based upon the facts, the children's right to a permanent home with the foster parents who've had them since they were 1.5 years old, who want to adopt them.
There is no question that it is very important and imperative that these cases be resolved in a speedy fashion, but we cannot throw the Constitution in the garbage with respect to people's rights in order to get there. That is the concern that I'm hearing here.
Thank you, Your Honor.
Thank you.
Just to jump off of Judge Troutman's last comment, best interest we submit does not trump the right to counsel. There's no presumption that termination is in the child's best interest. The Supreme Court said that in Santosky versus Kramer. The right to counsel also serves the fundamental interests of children facing the possible permanent loss of their parents. Given that, New York's commitment to preserving families whenever safely possible is meaningful only if this court instructs family courts in their responsibility to ensure robust representation of parents in termination
So
proceedings.
were we to reverse, I assume that the state could still start a termination proceeding based on current evidence, and the foster parents might end up adopting the children.
Absolutely, absolutely, Your Honor. The right to counsel is so crucial, and we would submit that it was not, had the court simply engaged in the proper inquiry, saying, we don't have a record here. Of course we don't have a record, because the court was not interested, was not solicitous of Beth's constitutional rights when,
But your first argument is that before the court is even engaged in any inquiry, that in those first few minutes, it's obvious. But that's your argument.
Yes.
It's obvious that this counsel is ineffective.
Counsel, can I get your perspective on this issue of 5 minutes, 10 minutes, 15 minutes? Can a highly experienced panel attorney who's apparently, from what I heard, done many of these cases, could they spend 5, 10, 15 minutes talking to the client before the hearing begins and get enough information to begin the process of conducting the hearing?
I wouldn't want someone representing me doing that.
No, that is suboptimal. I think we can all agree to that. But is it ineffective assistance as a matter of law if there's only 10 minutes of conversation?
I believe what the judge says, I have time to get a cup of coffee, and we just presume that's 5 minutes.
I think I'm asking because, excuse me, the brief amount of time I spent in family court, far, far away from Onondaga County, that happened a lot. Counsel were assigned, they were given a few minutes to start the hearing, not necessarily finish the hearing, but, there wasn't a huge amount of time prior to the counsel having to come into court and perform. And I'm just wondering whether that was just legal error that was happening every day in the family courts of New York City.
Well, I mean, in this case, it was, I believe, 11 weeks.
That's how much time he had,
Yeah.
and he could have, and he didn't. I'll give you that. But I'm talking about this brief opportunity that the court gave counsel to speak with the client, and I don't think it's very clear whether or not he spoke with her or didn't. But if he did, could that be sufficient to say that's not ineffective as a matter of law?
I would submit no, Your Honor, because of the stakes involved here, because of Beth's history, because of, her lack of legal knowledge of this, and the scope and the complexity of the case, as the amicus people wrote in the amicus brief. It's an extremely complex matter, which requires, I think, more than 5 minutes to sit down and talk to your client about it.
Counsel, just to go back to my original point, and it's been talked about, I know, but, so we have, in this case, an alleged constitutional violation. We have a best interest of the children argument. It seems to me in a criminal case, very serious, you can undo a trial, and people have to go back and put this show on again, and a lot of resources will be spent. But you don't have a child waiting for adoption. So that seems a little bit different to me. So my question to you is there any way, in any case, constitutional violation or different error, that you can factor in the best interest of the child and what's going on with the child's status, and I think what they describe as limbo, in a termination proceeding?
I think the problem is, as I said, there's no presumption that termination is in the best interest. The other problem is you can't really...
Let's say they make out that case that it is.
The problem is when you don't have effective assistance of counsel, can you really
But what
trust...
about a different error? Can we factor in a different error in the
I
termination
think
proceeding?
I would submit, under the facts of this case,
But
no.
you're not asking for all-size rule.
No, I'm not asking for an all-size rule. I'm asking basically that this court enforce the rule as it is regarding the inquiry, the waiver inquiry, also regarding the request for new counsel inquiry, where the court basically shut it off entirely, and I submit that more is needed.
Thank you.